Good afternoon, everyone. We have the immense privilege today of speaking to Justice Tejas Karia, who is literally writing the book as it is on the intellectual property law and its conundrums as we see development of AI and changes in technology today. So thank you very much for joining us today. So when we're talking about AI, generative AI is literally at everyone's fingertips these days. Governments, industry, institutions are building large-scale tools using AI. And with all of this comes the question of ownership and inherent risks that are involved when it comes to misinformation, deep fakes, violations of rights, etc. So first of all, sir, if I can ask you, does the human author principle still, as far as content is concerned, still stand firm in Indian law in face of generative tools? And what are the copyright laws that AI enjoys in India?
Thank you. It's a very interesting topic and a very pertinent one because we see a lot of cases arising out of this generative AI, deepfake, and issues arising out of the personality rights of individuals who needs protection in today's world and age, where the technology has taken a very expansive leap in terms of generative AI and other aspects. To answer your question, definitely the human author and the recognition of author in our Copyright Act is very much holds because what happens is that the way the law has been drafted, they have not kept in mind the development of the technology. And with the existing law, the way it is interpreted is that the author is a natural person. And a natural person's skill, art, and the labor is recognized by way of the intellectual property. The fundamental provision of the intellectual property law is human intellect. But what has happened with the technological advancement is that due to generative AI and other technological advancements, we have seen that many of the creative work is created by the technology with very little human intervention. So instead of creativity, now it is by humans, it has become a creativity by machines. And the question comes up that who is the author? The author, is it the person who has made the algorithm? Is the person who has given the command? Who is the person who has created the platform? And all that questions are yet to be answered. But as on date, the law is centered towards the human authorship and the human intellect, which is very much foundational on the intellectual property law. So we will have to see and evolve the law by which we need to ensure that the concept of the existing laws can apply to the new technology, or we will need to mold or change the law to keep pace with the technological advancements.
So just last year, in response to a question in the parliament, the government had in fact said there is no requirement to create a separate category of rights for AI and related innovations in the Indian IPR regime, as the Copyright and Patent Acts are well equipped to protect even AI-generated creativity. But when we're talking about balancing, I'm so sorry. When we're talking about balancing the rights and this technology and legal protection gaps, how can India then encourage AI innovation and in the creative sector particularly, while ensuring that rights are protected, while ensuring that authors are recognized?
See, there is a need to strike a balance. We have to protect the originality and creativity. At the same time, we need to protect the rights of the individuals. And that can be done by various technological tools as well as the legal measures. And as you rightly said, the law is there to protect. The only thing what we need to do is interpret and implement the law in the manner that it applies to the new challenges which we face in this world. Now, technologically, what we can do to build trust in this technology is to use the tools like watermarking, going by traceability tools or meta tagging the thing, just to understand whether it is an original work or it is a AI generated work, so that the user or the consumer at the end of the day is aware about the source or origin of this work. At the same time, we will also have to see whether we can identify a human or an entity which has created this AI-generated or a deep fake product, which can then be treated in a manner in which if it is not violating anybody's personal right. So what we need to do is we need to take the support of our constitution, which is a living document where all the rights are protected of the humans, and ultimately what we need to do is that within the four corners of the constitutional framework and existing law, we need to understand that ultimately the law is to protect the individuals against the wrongdoing or misdoing by the persons who are there to harm either the reputation or personality of a person. And if we are able to stop that through technology, we should try that. There are automated tools, there are various mechanisms whereby we can stop that. And if not, then the law has to be reactive and at the same time also proactive in certain aspects where the law can ensure that no further instances of this misuse of AI can be there. And for that, the enforcement mechanisms, training, awareness, and also change of culture is also very important. When we are accepting certain aspects, we need to see this, the next generation is able to understand the difference between the creativity, their artistic freedom, at the same time also protecting the human dignity and the personality rights. So that balance has to be drawn. Nobody wants to stifle the growth of creativity. Ultimately, it's in the interest of the digital economy that there is more and more creativity, there is more content which comes out of the technology, but the technology also has to be used responsibly. And that is very important, because unless and until there is a responsible use of technology, we may not be able to protect the individual rights, and the law is made for that.
So when we're talking about individual rights, let's come to one of the cases that is being very much talked about, the Aishwarya Rai deepfake case. You were hearing this matter as well, and there are orders that you've passed in this as well. This case and several others along with it, similar to it, bring together a question of personality rights, fake, deepfake creations, privacy, reputational harm. Where do you see this debate going? Because this is not just Aishwarya Rai. There's Amitabh Bachchan, there's Abhishek Bachchan. There are multiple other cases. I believe most recently, Hrithik Roshan has also moved a court on similar issues. AI is being used for fake information, fake videos.
Yes, so you are bringing a very larger issue, and the larger issue is that a personality rights of humans, which is akin, it's foundational on the right to privacy, and misuse of somebody's likeness or personality, the voice, the picture, all that is personal to someone, and ultimately what it matters is that it is not misused for commercial purpose, and with the use of technology that has to be prevented. So ultimately what we need to see is that the technology should not inflict the personality or the right to privacy of the human beings, and the law is there to protect it. Although there is no such statutory provisions, with the case laws which we have developed over a period of time, under Article 21 of Constitution of India, and also the Copyright Act and the Trademark Act, we have identified these rights as a separate category of personality right. And there are certain principles which we have taken into consideration. The first one is the recognition of the right against the digital impersonation. So what happens is that there is a digital impersonation happening through technology, and this is not only a means of privacy invasion, but it's a distinct tort constituting a wrong. So ultimately, what we need to ensure is to prevent the digital impersonation of the person. The second most important aspect, which is there for the personality right cases, is extension of personality rights into the virtual domain. Now, you have the human's personality right in the real world, but what has happened is that in the virtual world, where the AI-generated images, voices, and likeness is there, now we have seen it has extended towards the virtual world as well. The third aspect is obligations on intermediaries and platform to deploy reasonable due diligence mechanism to detect, label, and remove these deep fakes that infringe the identifiable individual's rights. So which is also very important aspect where there is an immunity the intermediaries enjoy, but once they have the knowledge or there is an order of the court, the intermediaries are bound to follow the orders of the court and ensure that no further instances of the same infringement takes place of the personality right. And the fourth aspect, and which is very important, is accountability of AI developers. Because ultimately, the AI developers provide this platform to create these deep fakes, and the people who want to misuse this platform are taking advantage of that. And if they have any ability or they should ensure that these tools cannot be used to weaponize for identity fabrication. So this is very important aspect which has been recognized in these cases. So fundamentally what we see is that these challenges makes us rethink the moral architecture of our digital public sphere. And ultimately, the law cannot function only as a reactive mechanism. The law must insist that the image of a human being, their face, their voice, their mannerisms remain as its core, the extension of their moral and legal identity. So that is the foundational basis or fundamental issue which we need to keep it in mind while deciding the personality right. But at the same time, we cannot stifle the legitimate creativity, parody, or artistic experimentation. The challenge is really here where the courts have to really determine is crafting a legal standard that distinguishes the harmful impersonation from protected expression. So which is very important. The protected expression cannot cross the boundary and harm anybody. And that is where we see that there is a defamation law which strikes a balance between a freedom of speech and a reputation. We will have to also see that the personality rights are protected while protecting the creative and originality of the creators. So that is the balance which we always should keep it in mind while dealing with these cases.
So, if I may move from the personality rights based question, and this is something that I apologize, this was not part of the questions that we discussed earlier, the Suryast painting case, when we move from personality rights or parody to actual creativity, when somebody is creating using AI, and we've seen how that has played out in the Indian copyright offices as well as in the US. In India, it was given copyright, but then it was withdrawn. In the US, it was not given at all. And we are talking about artistic creativity via AI and the questions it poses. And it comes right back to our first topic of conversation. Is AI recognized as a creator? Where do you see this entire debate going?
Very interesting question. Now, we have to see what is the creativity. First, we understand what is creativity and what is protected. Now, what is protected is intellectual property of a creator or an author or a painter or an artist who is really putting its hard work, experience, and trying to develop an art. Now, once we have the technology who is not a human, we need to see who is the creator, who is the author. So ultimately what we have seen as per Indian law Indian law doesn't recognize anybody who is not a natural person to be the creator or an author. And that is where we need to really understand that can AI, who has been created by humans, and there are algorithms and the data set which is fed into the system, can be a creator. Now, what has happened over a period of time, instead of a creator, the humans have become like an overseer, in the sense that they are overseeing the creation. And that is where we need to understand whether we can identify the closest link between the AI-generated artistic work and a human-generated artistic work. If we can see that there is a human intellect which is put into the AI-generated artistic work by creating a platform or a tool which will then generate the artistic work, there may be a possibility that we are able to have the law recognize the AI-generated artistic work. In UK, there is a possibility where the computer-generated work is recognized, but even then, the computer, when this law was made, it was where the computer was following the instructions of humans, and therefore, the humans were causing that work to be created. But now the generative AI can generate the artistic work without intervention, or the least intervention by the humans. And that is where the challenge lies. Ultimately, what we need to decide is that who is behind this creativity. And if we can identify the author, then definitely the law should recognize it. If not, then we may need to create a separate category and understand whether this kind of work needs protection. And if it doesn't need protection, then we may not need to grant something which is a separate protection to a separate category of work. But if it requires protection and if it violates somebody's rights, definitely we should take into consideration that whether the law can be extended or interpreted to this work as well, which is generated by AI.
So that actually brings me to my next question, which is, do we need new legal categories for protections, for when it comes to algorithmic authorship, when it comes to digital likeness rights? Where are the gaps in the law at the moment? Because we are seeing, people can create a book just by putting in certain prompts into softwares. People are creating videos just by putting in prompts. Where are the lacunae, where are the gaps in our laws?
See, to answer a question, we need to ask another question, is that can our existing law or the notions of creativity, originality, and identity, all built around the human authorship, survive the advent of machines that create, initiate, and even innovate? So that's the question we really need to answer, but to answer your question whether we need a separate category. So at its foundation, the intellectual property rests upon the simple but a very profound assumption that creativity originates from human intellect. And that is very, very important aspect. The artificial intelligence challenges that premise by generating works that are not merely derivative, but often original in functional sense, produced without any human intervention. So the question is now whether is the law prepared to recognize an algorithm as an inventor or an author. And the current form, obviously, the law is not equipped to recognize that, and that's the gap which you just identified, is that we need to fill that gap. And if we determine that whether there is a sufficient human involvement is there in creating that work or authorship, then definitely the existing law would be sufficient to protect that kind of work. But if there is no skill, judgment, or labor by humans, it is purely a machine-generated thing, then there may not be a possibility that the existing law will be there. And for that, we cannot confer the legal personhood to a machine. And what will happen is that the machine cannot bear the moral and legal responsibility, because there are also moral rights of the author, and the machine cannot have that kind of ability to have the moral authorship. And the law should evolve to assign liability and ownership to the closest human agency in the creative chain, whether either it could be the developer or it could be the user or the deploying entity, or it could be also the last person who has given the prompt, or the person who has trained the machine or caused that artistic work to be created. So therefore, the challenges are basically twofold. The first one is interpreting the existing law in the light of the new technological developments and the new realities. And second is to articulate the principles that will guide the future legislation. So we need to be aware of these two concepts and understand the existing law, interpret it in a manner which is more meaningful and protects the creativity at the same time, does not overstretch the existing law to the level where we apply the law to the situation which is not contemplated at the time of making the law. And also decide the cases in a way that we can decide the future policy and the lawmaking process and aid that in a dynamic way where we can anticipate the technology and then have the laws which can then counter the misuse of that technology. So ultimately, the future of law, the change of law will be measured not only how well it continues to protect what makes the human creativity, but the law must evolve to regulate innovation, but also to preserve the humanity within it. And ultimately, as we enter this age of algorithmic authorship, it is worth remembering that the technology may generate art, but only law can ensure that the art remains anchored in justice.
So just to sum up our entire discussion, if you could tell us what foundational steps can India take to ensure that its creative economy thrives responsibly in the AI age? Because we are talking about building a creative Bharat.
Yes, we are very conscious that we need to create creative Bharat. And for that, the law plays a pivotal role in every aspect. This is not only a policy-making project, it's basically a constitutional project. As I said earlier also, the Constitution is a very important document where all our fundamental rights are enshrined. And what we need to do is we must proceed on several fronts at once. Law alone cannot suffice to make a creative Bharat. The regulation alone also will not be sufficient, and even the market cannot play the role individually. What we need a collective effort to ensure that the law addresses the problems at hand, which includes the statutes or targeted amendments to the statutes that recognize the personality rights, provide clarity on ownership and accountability for the AI-generated work, and also set out the duties for intermediaries when the systematic misuse is there of AI in violating individual rights and their interest. At the same time, the courts should develop doctrines that interpret the existing statutes in light of constitutional values of dignity, autonomy, and free expression. The legislative changes should also be principled around the advancement of technology, and it should be technological neutral in the sense that it can continue to apply even when the technologies change. As I said earlier, a trusted ecosystem requires means to distinguish authentic works from synthetic ones. Where the synthetic contents affect public interest or targets individual. In compromising context, mandatory, hard to remove watermarking or provenance types like these technologies should be adopted. The legal principle should be disclosure that allows audience, platforms, and intermediaries to make informed decisions and also ensure that the state the government would invest in independent verification labs, open source watermarking tools, trusted timestamping services, and this should be affordable to to general public, journalists, and also the social media intermediaries, and also the civil society organizations who can play an important role in protecting the individual rights and striking the balance. So as I feel there should be a multi-pronged approach, the change in law or regulation or the courts cannot alone play a role in changing the mindset and creating a culture. We need to ensure that the technology is here to stay. It's not going to go away. The AI is going to be more and more pervasive into our life, and we cannot deny that existence of AI. What we need to do is to deal with it, ensure that we build the security systems around it, and ensure that it is not misused but used for making Creative Bharat more robust. And ultimately, we need to reach that level faster than any other country, because we are lagging behind and in terms of the technology, and the law will always keep pace with it. And I'm sure with technological advancement and legal developments, we will be able to create a very, very creative Bharat.
Thank you very much, Justice Karia, for giving us so much of your time. It is a very important new field of law that is developing as actors, journalists, even judges turn towards AI and AI is doing a lot in all of these fields. Thank you very much, sir.
A very big thank you, sir, and Ms. Mathur, for highlighting how fairness, rights, and respect form the true foundation of creativity. I would now like to request Ms. Supriya Suri, founder, Creative Economy Forum, to please come on the stage and felicitate Justice, sir.